Welcome to Women Entrepreneurship Week. I am Pamela Braza Pittman from the Conrad School of Entrepreneurship and Business, and I will be your moderator today. I'd like to mention a couple of housekeeping items before we get started. As you noticed, this session is being recorded and will be shared to our channels after the session for those who have missed it or others that want to catch it and watch it again. We will have time for questions at the end of the presentation, but feel free to raise your hand at any time or enter your question in the chat function, and we'll try to address it in between sections of the presentation. Again, thank you for joining the Conrad School today for our annual Women Entrepreneurship Week. This week, we celebrate women entrepreneurs along with over 200 other institutions around the globe. We have two speakers this week focused on topics to help women entrepreneurs succeed, but of course, everyone is welcome to attend. We also want to acknowledge the territory that we are on today. Much of our work at the Conrad School takes place on the traditional territory of the neutral Anishinaabe and Haudenosaunee peoples. Our University of Waterloo main campus is situated on the Haldeman Tract, the land granted to the Six Nations, that includes 6 miles of each side of the Grand River. Our active work towards reconciliation takes place across our campuses through research, learning, teaching, and community building. Without further delay, I'd like to introduce Joanna Ma, who is here to talk about strategizing your intellectual property. Joanna Ma is a technology lawyer who specializes in patents and designs and has an electrical engineering background. Joanna is a proud graduate of University of Waterloo with a bachelor's in engineering and went to receive her law degree at UBC. And I'll pass it on to you, Joanna.
Hi, everyone. Thanks, Pamela, for the introduction. So thank you so much for joining us today. I hope to make this as interesting as possible for you guys. And like Pamela said, I'm happy to take questions during the presentation. If you can either raise your hands or enter in the chat, and I'll address them as soon as I can. So let's proceed with the presentation. Just really briefly about myself and my firm. Bereskin and Parr LLP is an intellectual property law firm, which means that we practice solely intellectual property, and that includes trademark, copyright, patents, designs, and any on the outskirt of intellectual property, like regulatory, privacy issues, we also deal with. And you're going to get sick of me repeating these words because I'm going to go into depth about each of trademarks, patents, design, and trade secrets, a whole lot more. We have offices in Toronto, Mississauga, Montreal, and Waterloo. I'm currently situated in the Waterloo office, although we're not back in the office yet. But I was in Toronto for many years, and I decided to move back with my family back to Waterloo, and it's been great since. Like I said before, our firm practices only intellectual property, which means that everyone at our firm has some kind of technical background when we practice patent law. Like Pamela mentioned, I graduated electrical engineering from Waterloo, went on to do my law degree at UBC. We have people specializing in mechanical engineering, biomedical. In our life science department, we have a lot of people with their masters and PhDs in the various areas of life science. And we also have people specializing in litigation and trademark as well. And this is really unique to IP practice because we need to understand the technology associated with your innovation and invention. And so it's important for us to pair you up with someone who has some idea of what language you're speaking. I work a lot in the software space, as well as more system-driven innovation. And so it's exciting for me to work a lot in the Waterloo region. There's a lot of innovation coming into play right now. And it's exciting to learn all about it. So today, what I hope to do is to discuss really briefly the types of intellectual property, just to give you an idea of what IP really is. And then I'm going to go through that with an example with the iPhone. And then following that, I'm going to talk about IP and your business, effectively what your IP could be. So identifying your intellectual property and understanding how to protect that, with the case studies I'm going to discuss afterwards, as well as why IP is important at all to your business. So following that, what I want to do is talk about IP strategies with reference to 3 different case studies. And the 3 case studies I'm going to discuss are going to be varying intensity in terms of how they have developed their IP. And so it'll be interesting to compare and contrast what different businesses or how they have evolved their IP strategy. So I'm going to go right into the different types of IP now. So at a high level, these are the types of intellectual property we're going to be discussing. The first one is called trademarks. And so a trademark is important for protecting your brand. And when I say brands, we're talking about how the public perceives your business. Think about Apple, for example. The word Apple now is synonymous with a very, very popular technology company. When you say Apple, most people are thinking of iPhone, of computers, of many products that are no longer just about the fruit. And so Apple has done an amazing job of developing a brand. And in order to really well protect that brand, they have applied for a lot of trademarks. And I'm going to go through those examples, some of the examples with respect to the iPhone later on. And other brands that are well known in Canada or other parts of the country, world, Canadian Tire, Costco, for example, they are all protected with some version of trademarks. And that's what we're talking about when we're talking about trademark protection. We're using ways to protect your brand. And moving on to copyright. So copyright is used to protect creations. And what does that mean? Creation is very ambiguous in some ways. When we're using copyright, we can protect a literary work, for example, a book. We can also use copyright to protect music, the lyrics to music, and potentially even a computer code. And so I'm going to go into more details to how software is protected. You can definitely use copyright to protect a piece of computer software, a computer code, but you can also use patents to protect computer software. And I'm going to explain the differences in terms of what type of protection is actually available, the scope of protection available via copyright for software versus patents later on. And then so finally, for inventions, we have different types of protection available that I'm going to go into depth about later as well. The first one is called industrial designs. The US has an equivalent called design patents, which you might have heard of more. But what industrial designs cover is how things look and feel. An example that is you might have seen in the public in the area is the bottom glass, for example, the shape of the glass bottle, the glass itself. And so I'll go through examples to explain exactly what that means. Trade secret is another way of protecting your innovation. Coca-Cola recipe, for example, the KFC recipe, for example, is protected via trade secret. And finally, patents, which is the area I specialize in, can be used to protect innovation. And so we'll go into detail about each one of these with respect to the iPhone. So with the iPhone, all these different types of IP can be used and has been used to protect aspects of it. And so I'm going to go through examples to give you an idea of more concretely of what that means. So with respect to the iPhone, these are just example trademarks I took a screenshot of from the Canadian Intellectual Property website. So once you file for a trademark application, you can actually search for this trademark application publicly through the government portal. So in Canada, that's CIPO, C-I-P-O, Canadian Intellectual Property Office's website, and equivalent in the US as well. And that's really interesting to note for you, because one of the things I do very highly recommend for entrepreneurs when they're first going into the business is to do a quick search of your name, at least your business name, or even your product name, just to see what has been registered or what has been applied for by other people. And it gives you an idea of how open that name is for you as a business to grow into, and what problems you may encounter when you do want to register for it. So going to this example here, we see that iPhone, there are many versions of these registration for iPhone, the trademark. Just this one example, the first one here for application ending in 390, we see that iPhone, the word has been registered. What this iPhone word has been registered for is to be associated with specific goods, which have been laid out here: digital telephone, adapters, analog telephone, etc. And you can see afterwards, the application number ending in 364, iPhone has been registered, the word iPhone has been registered for specific services laid out here. And so that's another thing unique about trademarks. When you are applying for trademark protection, you need to specify the specific goods and services that you intend on using that trademark for in terms of your business. What will you use that text for? Or as you can see, other forms of trademark can be sought. It can be with logos of pictures like this. It could be alone, the icon can be alone or in combination with text. So you need to tell the government office exactly how you intend on using that text. And that's really important in terms of later on, once you do have registration, how you intend on using that. Because ideally, once you have this registration, you do have that trademark protection, and you could use that to prevent others from invading your branding, right? So you could use these to assert against someone else to prevent them from using whatever trademark you have gotten registration for. And so what's important about that is if you don't clearly define your services or goods, or what I mean by clearly is you want to be as broad as possible with the text to cover the complete scope of your business. You don't want to just cover so narrowly that someone else could then try to use that trademark for another version of what your business is about. So as you can see here in the first example of iPhone, they have many versions of what telephone is, and the telephone adapter as well too. They have gone very broad in terms of what those goods and services, and the second one, covers, so that they can more broadly apply this against anyone who might try to use iPhone as their branding in terms of their competition. And as you can see afterwards here, what Apple has done is iPhone 4S. You don't necessarily need to register every single version of the iPhone. They've done that for 4S. I'm not entirely sure why. Apple does have a lot of money backing them. I did a quick search just before this presentation. It doesn't seem like they have registered for every version of the iPhone, but you can see it with IP, there is a cost with everything. And so it really requires a lot of understanding of what's important to your business. And I'm going to go through that when filing for patent protection. Not everyone's in Apple's. And so you kind of need to prioritize what's important to you. And so these are an example of trademark for the iPhone. One other thing that's really important with trademark protection is we live in a common law country. And so what that means is there is common law trademark protection. And so it is possible for you to obtain protection for your trademark, so for your branding, without necessarily registering. And that's really important to understand. It's really important to understand what that means. With common law protection, which means you're not registering through the government entity, you start using your trademark. I can say I start Joanna's Bake Shop in Kitchener-Waterloo. And I start developing that brand. Everyone in Kitchener, KWC area knows me, and even potentially in Toronto knows about Joanna's Bake Shop. And so over the years, I've developed common law protection for my trademark, Joanna's Bake Shop. And I have that for the region, KWC Toronto, and maybe the outskirts of GTA. And so with common law protection, I'm just restricted to a very specific region. In contrast to that, with registration, once you are registered, if I registered Joanna's Bake Shop, I would have presumed right across the country. And so it's across Canada. I wouldn't have to, versus common law protection, I would need to, if someone were to try to open a Joanna's Bake Shop in BC, I would need to show examples or evidence that my common law protection on my branding has spread so far across the country that I should have that branding protected through common law in British Columbia. And that's going to be difficult, likely. The term Joanna's Bake Shop it's actually probably very difficult to protect. Also, I wouldn't really recommend it as a trademark or a business name. And so that's one of the disadvantages of relying solely on common law protection for trademark. It doesn't give you a presumed right across the country. And so I do, depending on the type of business and what your financial situation is for the business, trademark can be very critical or can be a later priority, depending on the situation. And I'll go through different examples later on. And so I'm just looking at some of the questions here. Right. I think these questions I'll definitely address later on with the case studies, and if not, then I'll address them in more detail afterwards for sure. And then so with respect to the copyright for iPhone, copyright is not very expensive to file for. It's a matter of submitting a copy of the piece of creation to the Copyright Office and getting a stamp for it. With iPhone, it was a little difficult to search for examples. And what these listed examples are actually video clips. And I think video clips are music. I think it's video clips that Apple had taken with with iPhone 7, and they had registered copyright for that video clip. It's not necessary for them to do it, and like I said, with IP protection, it really is. It depends on how much money you have and how much you're willing to spend for that budget. And so Apple decided it was critical for them to file protection for it, and like I said, copyright's not that expensive, and so they did that. I mentioned before that you can use copyright to protect software code. I wouldn't really recommend relying solely on copyright to protect software. As I mentioned before, copyright is used for protecting creations. And so the typical use of copyright is to protect literary work, so such as a book, a novel, the text in the novel. And what that protects for you is to prevent someone else for copying substantially the same text in the order that it appeared in. And it's a little subjective test as to how much copying and how that copying really becomes copyrighted, infringement of copyright. With software code, for example, it could be that someone produce a piece of code in Java and potentially someone else then sees that functionality, sees that piece of code and knows how it's operating, and then they decide to then copy that functionality in another type of computer language. Copyright then arguably may not protect that scope. It depends on how they have copied and translated into that language. It's a very difficult case to prove if you were to solely rely on copyright protection for just computer code, because you need to show that someone else had access to your computer code and also substantially copied it. And the word substantial in the legal field is a very subjective area, and then you need to show what substantial is and how much access they had and what they did. Various changes to the code and functionality could mean that they haven't substantially copied you. And so in contrast to that, I'm going to explain what patent protection means for software code later on, and I'll explain in detail why with software it's much more essential to consider where the patent could be more helpful to protect your innovation that way. And so going to industrial design protection in respect of the iPhone, these are examples of industrial design registrations that have been obtained for aspects of the iPhone. And so in the left example, we see that the shape of the iPhone has been registered. And in design protection, you can see in the contrast on the right side, anything in solid lines define the protection of the registration. So you can see that on the left here, what Apple has obtained in terms of its protection for the iPhone shape is all these, the button on the bottom, the microphone and the holes there, as well as the plug. And all these other, the buttons on the side, the exterior shape and the curvature here are all defined as the design of what they're trying to protect. What's really interesting is you might have seen in the news a lot of litigation between Samsung and Apple. Interesting enough, it's mostly dealing with design protection. And you can see some of the differences in terms of I'm a Samsung user, so when I picked up an iPhone, there are many differences in terms of the user interface and the buttons, for example. A lot of that's driven by what each of them have in terms of design protection. And so on the right, you can actually protect user interfaces with design too. And that can be a very powerful tool, especially if your business is targeting more consumer-driven products. The most critical thing is for users to become comfortable with that user interface, especially if you invested a lot of time and resources to developing a very useful interface. And so what's interesting here is you can click on the text bubble and another bubble pops up for you to select a reaction. I have a lot of friends with Apple or iPhones, and they actually keep doing this, and I don't see it on my end because I don't have that functionality in my Samsung. And so what they have obtained in terms of this registration is having a text bubble along with this bubble popping up on top of it. This version is a little narrow because they have all these thumbs up and specific icons here. And what would have been more powerful in terms of registration is just this bare bubble on top with all of these icons in dashed line, so that it's not part of the defined protection. When you apply for designs, you can actually submit versions of these drawings, and Apple does have a version of this without a lot of these icons. So they do have a different level of registration for various versions of this interface. And so with a lot of my clients, I do recommend considering protecting your user interface with design. Design, in contrast to full utility patents, which I'll go through next, is fairly cost effective. And so it could be a very value added IP for your business. And so going to patents, we talked a lot about it already. These are some of the examples of the patents that Apple has obtained. And I'm not going to go into too much depth about what patent protection is, but when you see in the news article, when someone has supposedly invented or obtained protection for, like maybe just like a charging pad, for example, it's more than likely that they haven't obtained such broad protection as every single charging version of charging pad. With patent protection, utility patent protection, the scope of your protection is very specifically defined in a claims section. And so whenever I see very broad headlines like these, I pull up their patents and then I read their claims and I see, oh, it's a very specific implementation, likely. It's very rare for it to be so broad nowadays. And no one's really reinventing the wheel anymore. It's versions or iterations of that technology. And so when I pick up the patent and I read the claims, I can understand that it's really not that broad of a technology. It's a very specific implementation of it, and how you define the claims, and that's where we come in and develop claim language that is as broad as possible. And that's why it's important for your patent agent or a patent attorney to understand the technology as much as possible so they can define the scope of your protection as broadly as possible for you. And so some of these are really interesting. One of the things about patent is you need to file as soon as possible to obtain as early a date as possible. And so it's more than likely that you won't see the actual product until later on, way after their filing date, the patent filing date. And it's also possible that you can file for patent protection for products that never even it's commercialized. And one of the most critical thing about patent is you want as early a date as possible. So Apple and most of the tech companies tend to just file immediately. And later on in commercialization, they decide, oh, whether it's actually viable to even produce this. And you'll see even for a lot of technology out there, there could be patents filed and registered, and but never really commercialized. So these are examples of the patent that Apple has obtained. And so on the left here is an air power mat. And nowadays it's kind of everywhere, wireless charging. But the priority date on this is likely, all these screenshots are from Patently Apple. They monitor all the Apple patents that become published. And so it was published 2019, this article here. And so more than likely, patents are published for 18 months after you file. So more than likely, this was filed maybe in 2016 and 2017, depending on the filing strategy. And so on the right here, you can see that Apple obtained patent protection for this Animoji application, or I guess Animoji option. And what's really interesting is I actually studied this in depth in terms of their claim scope, and it's a very broad claim as to how they obtain this conversion from the face to the various different animal. But it's a very specific implementation of the software to obtain this conversion. And so it's just really interesting to see what exactly the covering, the scope is for the IP in terms of software protection. And then this one is just an example of the Air keyboard with a headset. And so you can see that with patents, we're covering, in contrast to all the different types of IP we discussed, patents are covering the functionality of either software, a physical component, or in life sciences, it could be variations of different types of products, for example. And so patents could be very powerful depending on your business and how type of products you have. And so this is just an example of some patents that Apple had filed in terms of with respect to iPhone. And so with the iPhone, we don't know the trade secret, and that's really important. With trade secret, it's not merely enough for you to just keep something secret. You do need to take active steps to make sure that you protect it well. And so with examples of KFC and Coca-Cola, their recipe is under really under well-protected, it's really well protected. With the KFC example, what I understand is they protect a specific ingredient that go in by having trucks bring in unmarked vats to factory A to be mixed together, and then they bring that mixed to another factory to be mixed with another unmarked mix of spices. Their employees do not know what the specific ingredients are that are being mixed together. And also, I believe that no specific individual actually knows all the ingredients that go into that KFC recipe. And so it's really important that if you decide to try to protect something with just trade secret, you take active steps to make sure that it's as confidential as possible. You limit the people who would have access to that trade secret to only essential personnel. Trade secret is really valuable for very early on development, especially with software, for example. But as you become more well-known, as your business grows, it's definitely important to consider different types of protection that we have discussed. Dr. Pepper is actually in some ways a little sad in terms of their recipe. For some reason, their ingredients and the recipe was found in a used book sale. And so it was just inserted in a used book, and their recipe is no longer protected by trade secrets because it was disclosed. So that's one of the disadvantages of relying solely on trade secret for protection. And so that's the example with the iPhone. What I want to do now is just to take a step back and give you an idea of how to consider what your intellectual property is. And we've gone through the different types of IP. And so for you now to understand or to think about what your intellectual property could be, these are some of the questions I would ask my clients when I first meet with them. What do you do best? What is it that makes someone choose your company, your business over that of your competitor? Effectively, what's your delta? How do you attract these? It could just be you're first to market, you have obtained a majority of the market by being first and marketing really well, or you could have a secret sauce that your competitor is unable to achieve in terms of potentially low cost, efficiency. And so what is it that makes you different? And that difference, will it be important to your continuous success overall as your business progresses? And so depending on the answer to these questions and what you want to do with your business, then we should hone in on that delta, the difference, and find ways to protect that as much as possible. And so briefly, why is IP important? At the end of the day, I think branding is critical for likely all business. There are companies who are less consumer driven, and so their branding is not as key. So a lot of software companies that are back end, branding trademarks may not be as critical immediately. But at the end of the day, IP is property. You can assign a value to it. It can be sold. It can be transferred to through license, can transfer by sale, or it can be licensed. So any of these types of IP I've discussed, a value, monetary value can be associated with it. So depending on the type of business, it may be valuable to have some of these, all of these. And so it's important to prioritize what could be important for your business. So what I want to do now is go through 3 different case studies of different types of IP strategy they have developed, or the first one may not have developed at all, and just explain, just to give you an idea of what that means in terms of developing an IP strategy. So I think this is a good time just to address some of the questions. So the first question we have is IP as powerful as how much money you can use to defend it? Right, so that's a really great question. With IP, you may not necessarily need to defend it. And so it depends on the type of IP you're trying to protect. With trademark, yes, you do need to assert that trademark against someone else. And so with trademark, it is critical that, and with one of these case studies, I'll explain, you can see clearly how they've done, what they've done to try to protect that IP as much as possible. And so with trademark, you do need to be very actively asserting against other people to make sure that you are you very much protect your trademark arsenal. With patents, on the other hand, you can assert it against someone else, but then it's up to them to kind of in some ways invalidate your patent once you have a patent. And it could be expensive, but it really depends on the situation. At the end of the day, my answer to this in general is if you have no IP protection, you can't even use anything to protect your business later on. And so I advise all my clients to consider what IP is critical for them. I don't say file for everything. It depends on the situation. And I say use the money that you have, use your budget for filing things that are important to grow your business later on. And so I think it's a balancing act in terms of how you use that money. So to address that question, yes and no, it really depends on the situation. And at the end of the day, we're not a litigious country. And so a lot of times companies are bought because of their existing IP. RIM is an example, Nortel is an example. Their IP portfolio really grew their valuation at the end. And the second question is how early or what stage of one venture should you apply for patent? Right. That really depends on the situation. And I'll go through that in more detail later on. And generally, I suggest to everyone to consider their IP strategy at every single stage. As early as possible, consider what IP means to them, what is important, and going through the questions that I have identified, and revisit that at every important stage. When you get new funding, for example, when you make a big significant sale, for example, big changes in your business should prompt a discussion or revision of your IP strategy. So just going to the case studies now. Sorry, Pamela, I think we have, is it 10 minutes or 15 minutes left?
We're hoping to start Q&A at 10:02.
Okay, all right, so I might have to go through these a little quicker. Thank you. And so Flappy Bird is just an example of someone who created a really cool app. I'm not sure if anyone has seen this app. It's very difficult to play. I'm not that great at it, but it's someone who created an app and it became an instant success without them ever intending it to be that successful. And so with this example, I'm just showing what happens when you have no plans to develop an IP strategy and things can go really wrong. And so if you're familiar with games and such, you can see that the pipe here, it's already very reminiscent of many Nintendo games. Let's see, with this Flappy Bird pipe there is very similar to a lot of these different pipes that exist in the game space. This one, for example, is from Super Mario All-Stars. Nintendo is very litigious. They're very serious about their IP. And so it's, before developing your app, your games, or anything really, you really should consider whether or not you're taking from the existing marketplace. And especially for companies like Nintendo, they're very serious about protecting their brand. And the backdrop to Flappy Bird is it was developed by someone who never really intended on making a success. He just loved to program this overnight, became an instant success. And so he never really thought it would blow up as much as possible, as much as it had. It actually was taken off of the game store because he didn't want to deal with that instant success. And so what Nintendo did say was they came out and denied being the cause of Flappy Bird being taken off the marketplace. But these are other examples of instances where Nintendo had taken action to prevent, to stop certain marketplace activity. So in the bottom left there, real life Mario Kart, and I think this was in Japan. I thought it was really cool myself when I saw it in the marketing, and I thought it would be cool to join. But Nintendo fought that, and it actually no longer exists. And so Nintendo takes things quite seriously with the games as well. The iPhone app, Duck Hunt, that was taken down because Nintendo took action against that, and as well also down here with the Gianna sisters. So Nintendo does make sure that they take action against the more popular versions of their games that come up. And so this is one example of how, if you don't really consider IP beforehand, it could be a big problem for you, especially if you gain such success. You can see here, Flappy Bird, once Flappy Bird became such a success, many different versions came out afterwards trying to copy it. The game itself is very simple. It's just a matter of touching the bird and having it fly through the different pipes. And so it wasn't, the functionality of it wasn't that difficult to copy, but, and so it's not easy to protect such a simple version of a game with the different types of IP we talked about. But what they could have done is try to protect it with more branding. And so versions of these all came out, and no trademark was really filed for Flappy Bird until later on, when the Dong Nguyen, who's the developer of Flappy Bird, decided to file for it. And so you can see many versions of Flappy Bird, Flappy Fish, Pig, Tappy, Flappy Dragons all came out afterwards that are all versions of that game. And so with the lesson here of Flappy Bird, it's just, you never know when you become an instant success. And so before doing anything with your business, it's important to consider how you can protect it. And when your business is like Flappy Bird, where your branding is key, you should really consider trademark protection, and at least do the search that I mentioned before on the government website, just to make sure that you're not intruding on someone's space already that exists. And you don't really want to spend money fighting a fight that doesn't have to be fought. And so consider changing your name, changing it so, or varying your IP or what's important to you up front, so that you can dominate the space without having to incur either later remarketing costs, later IP costs in terms of fighting existing branding. And so this is just an example of how things could go really wrong when you don't develop an IP strategy up front. With GoPro, what's really interesting with GoPro is that effectively, the GoPro camera is just a very small, rugged camera that can be mounted to a lot of different services. And at that high level, it's not that inventive. It was developed, it came out around 2001, 2002. And so patent-wise, it's very hard to protect it, to obtain a broad patent for that idea of a rugged, small camera. What GoPro did was, initially in the 2001, 2002 time, they obtained patents for a lot of the mounts and a lot of housing. And they dominated the market. They were the only one really in this active camera market for about 10 years. A decade, they dominated the market, and no one really came into the space until later on. And unfortunately, at that time, a lot of different competitors came in. So at the low end, we have cameras costing $30, or on Amazon, you can buy them from that range up to maybe $200. And at the other high end, we have Nikon and Canon coming in with very fancy camera technologies going upwards of $200 plus. And so that really sandwiches the GoPro GoPro development. Either they can't really go in the lower range, that's not really their target, and they can't really go like that much higher without sacrificing other aspects, because they can't really compete with camera technology that are Nikon and Canon, for example. And so over the top years, GoPro has really lost their dominant market. And so you can see GoPro was founded in 2001. And over this 10 years-ish up to here, their product line, this isn't all their product line, but some of their product line, the major ones here, they haven't really evolved that much up until here, which is more of a high definition digital camera. And then they decided to pivot into the drone space in 2015. And unfortunately, drone didn't work out for them. The battery on the drone actually kept falling. And so they decided to end the Karma drone. What they had done is they made a pivot. They tried to make a pivot to a drone. That didn't work out. But as part of the drone, they needed to develop software that really helps with stabilization and the image capturing. And so they moved towards the GoPro Fusion and Hero 7, which have really sophisticated stabilization technology. The Fusion actually has two cameras that take almost 360, together 360 video of the surrounding. And so they decided to make a pivot from just different mounts, different hardware components, and evolve into more specific software technology that are targeting the very active market. And so this is just an example of the different patents that were filed by GoPro. You can see, as I mentioned before, almost the first decade of their business, they didn't really file for many patents that are beyond the mounting accessory, because that's what they were really targeting, being able to mount the cameras to wrist, to bicycles, to helmets and such. And it's only maybe around the 2011 time, so like the green boxes here that show they moved towards more image processing, multi-editing, and they moved towards like drone technology here that related to this the Fusion technology with the 360 capture. And so with GoPro, what's really interesting, as you can see, is they dominated the market, but they didn't really make any headways in terms of the software, the anything beyond the mounting. And unfortunately, that allowed a lot of the competitors to come in and take over their share of the market. And so with that said, they pivoted and they tried to go into a different market with the drone, but that didn't work out. But what was part of the drone development helped them develop a niche to stay within the active action camera technology. And so this is just an example of the different types of patents that were eventually filed by GoPro. And so with GoPro, what's really interesting is they, like I mentioned before, they really took the initiative to protect their branding. They filed a lot of trademark related to the GoPro brand, and they did actively enforce it. So there's a lot of money involved in protecting it, but that was very critical because for most of almost the first decade of their business, they benefited from that first mover advantage. They effectively developed this action camera marketplace. But obviously there are costs associated with that too. And then over the years, they decided, they realized that they needed to protect themselves somehow a lot more in terms of preventing the competitors from entering or taking over the marketplace. And so they found ways to distinguish themselves, and that they were able to protect more via patents. And what's another interesting thing is the copyright aspect. They understood that GoPro is not targeting everyone. they're targeting people who are very active and people who love to be active and capturing the amazing things they do when surfing, when mountain biking. And so they developed this GoPro channel community where they host these contests with whatever videos you submit taken with your GoPro camera. And so they decided to target a very specific niche and offer technology that helped to achieve that niche's needs. And so you can see that GoPro made a pivot and they were able to assist or facilitate that protection with the different types of IP. And so just going through our last example here, Nest is a very sophisticated company. They were started in 2011 by ex-Apple employees. And so a lot of their design, you can see, it's very similar in some ways to Apple products. And so they took a very sophisticated approach to protecting their technology. And so with Nest, they started the learning thermostat in 2011. They released that. And then later on, they released the Nest Protect, which is for smoke detector and CO2, and as well as the Nest Cam. So I know we're a little over time, but I'll go through this really quickly so that you can understand a very sophisticated IP strategy. And I'm happy to take questions afterwards too. So with Nest, in 2012, Honeywell did assert patent infringement against them. Honeywell does that to a lot of different companies, and most of the time, many of the smaller companies that try to enter the space, they just kind of walk away from. But instead, Nest developers, they did not back down easy. They took quite some interesting, they took a lot of steps to fight back against Honeywell's claim. And then eventually Honeywell and Nest actually agreed to a very sophisticated long-term cross-licensing of patents. One of the things that was really interesting, what Nest did to further protect themselves in terms of IP, is they acquire patents that had priority date in 2004 and 2005, and some in 1998 as well too. You can see from the IP portfolio. And going back here, you can see they didn't really exist until 2011. So what they did was they found patents that were interesting for their technology as they developed their brand, and they bought them and they acquired them to boost up their branding, and that really helped with their fight against Honeywell. And so in 2014, another thing that was really interesting in how Nest further boost up their technology and branding is they acquired Dropcam. And as a result of that, they acquired their IP before they introduced their Nest Cam. So Nest is fairly sophisticated, like I mentioned before, and so they knew that there's existing IP out there in patents. They can acquire it, they can obtain it, so that becomes part of their portfolio. And if they are companies out there that can help boost again, accelerate their product launch and their product development, they can acquire that. So Nest, in contrast to GoPro and Flappy Bird, is a very different way of developing an IP strategy. It also did help that Nest was funded by Google at one point, and also was acquired by Google. And so they did have likely a very good budget in terms of developing an IP portfolio. And so another point about Nest's patent portfolio that was really interesting is likely because they have that Apple background, they didn't file for just utility patents. They realized that because of the product, it's very consumer driven. The design aspect of how it looks and feel is very critical to protect as well too. So you can see that about 1/4 of their portfolio is design protection. And just quickly about the IP acquisition, intellectual ventures is a patent troll. So patent troll are entities that don't necessarily practice the technology, but hold a lot of patents, and they send out a lot of letters to different technology company asserting infringement of their patents. So Nest got that letter, and aside from just licensing the patents from intellectual ventures, they also consider what patents they had that would be useful to them. And they acquired a bunch of them, and they had priority date as early as 1998. And so, as you might remember, Nest didn't exist until 2011. So that really helped boost the value of their intellectual property portfolio. And so these are just examples of design patents. As you can see, they have very different versions that protect different levels of their design patent designs. And so that's really critical for them to understand. Like with a very consumer-driven product, you want to protect it as much as possible to prevent your consumers from going somewhere else, right? And once you're used to it, it's more than likely you don't really want to make the jump to other technologies. So as summary, Nest took a very serious approach to IP protection very early on. They are very sophisticated in terms of their starting individuals who they're ex-Apple employees, and so they really understood what's important and how to protect that. And they were open to different ways of supplementing the IP. And so this isn't necessarily the way for everyone to approach it, but it's interesting to consider that you don't necessarily need to file and develop all your products and technology. You could find alternative ways to make sure that you're protected in every single direction possible. And so these are just takeaways from this discussion. As I emphasized before, it's important to align your IP strategy with your business goals. Your IP is really a business consideration. If there's no value in the IP at the end of the day to boost your business, to accelerate it, there's really no point in developing or filing for IP protection. And so consider your IP strategy as your business evolves. Review your IP strategy at each milestone, and every time you go into a different marketplace in terms of jurisdiction, consider if you should alter your IP strategy. Consider a strategy to commercializing your IP. And so consider what you intend on using your IP for. Is it just to invest in investors at this time? Is it to facilitate commercialization and licensing, or do you want to sell? Or do you need to protect your competitivity? And so, think of what's important to your business at that time, and then consider how to protect it. And finally, with IP, patents, for example, have a life of 20 years. Generally, it depends on, it could vary a little depending on some jurisdiction. And so it's important for you to think of how your business is going to grow. Where is it going? How do you want to protect it? In terms of technology, like how is it going to evolve? Like you need to make sure that that's well protected in terms of the patent protection. Trademarks could be forever, as long as you pay the maintenance fees and you consistently use it. And so think of how your branding may evolve and how you might want to evolve it over time. And so you can make the filings necessary as soon as possible. And so with IP, it's important to evolve it as your business grows, but also think ahead as to how it could help accelerate your business. That's all I have for now. I think I addressed all the questions there. Yeah.
Thank you so much, Joanna. That was really insightful and very practical knowledge for our entrepreneurs that are on the line and those that's going to be viewing this video later. We have like a minute. If somebody has any questions, feel free to just unmute and jump in to the conversation, or Joanna's email is on the screen, although she is on mat leave. So feel free to forward it to me if you have any questions, and we can arrange some answers for you.
Hi, can you hear me?
Yes.
Yeah.
This is Monica speaking. I had a friend recently who waited on incorporating a company because they want to bring in more developers. And he actually introduced a professor in the States into the project, and somehow bringing him into the GitHub, he actually got kicked out of his GitHub account and had his software taken from him. After the fact, there's not much he can do, right? When something's already been taken. But he started the GitHub account. He programmed for 6 months on this project. but this professor had access to the account and just took over the project and locked him out one day.
Oh, that's an unfortunate situation. It really depends on the situation, and I'm happy to connect you with the right people or your friend to discuss that more. It doesn't sound right. And it really depends on their agreement. And so one of the things that I really emphasize to clients, especially when they work with different entities, is to make sure that before giving their secret sauce, to make sure that they have a specific legal agreement in place in terms of who owns what they can control and what can they do with it. And so I'm not entirely sure of the situation between your friend and the professor and potentially the research group. And maybe even the university, and I think Wayne can add in, or Esteban can add in more about this, but Waterloo has a very open source in terms of what the university may own and the students. So there are a lot of things in place. So I can't really address that right now. I'm sorry.
Oh no, thank you very much.
All right, so we're a little bit over time. Thank you again, Joanna, and thank you for everyone that joined us. Join us again this Thursday at noon for Dr. Neda Basir to speak on social entrepreneurship. The registration is on our website if you want more information. Thanks again, Joanna. I hope everybody found this session helpful. I know I did. And have a great week. Thank you.